We will talk about an old patricide case in Japan, usually referred to as the Tochigi patricide case. And this case had great impact on the criminal law of Japan. And first, we will talk about the Tochigi patricide case and the judgment of the case. Next, we will compare the majority opinion of the judges to the minority one and explain the later situations related to this case, thinking about morality and law. First of all, let me introduce the tragic patricide case, which happened about 50 years ago in Japan. The Tochigi patricide case, or Aizawa patricide case, is a father-daughter incest and patricide case in Tochigi Prefecture, Japan. The trial of the incident is also known as its common case name, Aizawa versus Japan. In the incident, a victim's daughter, Chiyo Aizawa, who had been sexually abused by her father for about 15 years, eventually killed her father in 1968. She was accused and convicted for murdering her father, but her sentence was suspended. Her controversial trial led to a change of parricide's penalty in the Criminal Code of Japan. The background of the murder is as follows. Born in Tochigi Prefecture, Aizawa was the first of 6 children. Her father was Takeo Aizawa, and her mother was Rika Aizawa. Takeo Aizawa was an alcoholic and systematically raped his daughter from 1953 onwards. Takeo Aizawa's wife, Rika, fled to Hokkaido, a prefecture far from Tochigi, soon after, leaving Chiyo behind. She returned several years later, attempting to stop their relationships. But by then, Takeo was living with his daughter, treating her as if she were his wife. Chiyo Aizawa became pregnant 11 times and had 5 daughters by her father, 2 of whom died in infancy. In 1967, she underwent sterilization after her 6th abortion. In 1968, Aizawa fell in love with a 22-year-old man, and her father became angry. He confined her and said that he would kill her 3 children. On October 5th, 1968, she strangled her father in Yaita, Tochigi Prefecture. At that time, the penalty for parricide was the death penalty or life imprisonment under Article 200 of the Criminal Code of Japan. What is the problem of Article 200? Surprisingly, when you kill your parents, you cannot avoid the strictest and the second strictest punishment in Japan without considering the circumstances. Moreover, this punishment cannot be granted a stay of execution, meaning lighter punishment. Justices typically accept mitigating circumstances in such incidents. Japanese laws at the time permitted 2 reductions in actual sentencing, each reduction half of the appropriate sentence, with life imprisonment reduced to a 7-year sentence when reduction is applicable. Still, the minimum sentence Aizawa would have received was 3 years and 6 months in prison, and the laws at the time did not allow suspended sentences for terms longer than 3 years. It is the matter of the balance between crime and the punishment. Her lawyer insisted that the murder was self-defense and that she had been insane because of the rapes. The Utsunomiya District Court considered Article 200 unconstitutional and acquitted Aizawa because the crime originated via self-defense. However, the Tokyo High Court did not concur and sentenced her to 3 years and 6 months. In a final appeal, the Supreme Court of Japan accepted the argument that imposing a harsh penalty on Aizawa would violate the principle of human equality before the law found in the Constitution. The court ruled the article unconstitutional in 1973. Why had the court ruled the article unconstitutional? This is because the judgment of unconstitutionality is the only way to protect Aizawa from a jail sentence. Article 199 about homicide provides that a person who kills another shall be punished by the death penalty or imprisonment with work for life, or for a definite term of not less than 3 years at that time. So Aizawa was found guilty of regular homicide and received a sentence of 2 years and 6 months in prison, suspended for 3 years. If the court had not annulled precedents, she could not have received a suspended sentence. She was effectively acquitted, and she worked in Utsunomiya after her release. Before the judgment was concluded, there were 2 opinions among the judges. In the Constitutional Review of Japan, the court considered 2 points of view: the purpose and the means of the law. When the court ruled that the purpose is unconstitutional, it will review whether the means is unconstitutional or not. In the majority opinion of Aizawa versus Japan, the theory with the purpose is constitutional but the means is not was upheld. In contrast, the minority opinion, the theory with the purpose is unconstitutional, was affirmed. Next, let's contrast 2 theories and think which theory is better. What divided the judge's opinion was the purpose of Article 200 of the Penal Code. On one hand, the majority opinion considered that the purpose was protecting a universal ethic. A universal ethic means that it is natural that 2 people whose relationship is so close love each other. In view of the universal ethic, the purpose is proper. However, the means, the death penalty or imprisonment with labor for life, is too severe for Article 200 to be constitutional. This is the logic of the minority opinion in finding Article 200 unconstitutional. On the other hand, the minority opinion insisted that the purpose was protecting a feudal ethic. Jiro Tanaka, one of the judges of the Supreme Court who gave the minority opinion, insisted the following: the background of legislation of Article 200 is not only the idea of the severe punishment for parricide in the feudal age, but also the family system, which was specially emphasized in the age of the Meiji Constitution of Japan, considering Article 200 provides not only the parricide by the ascendant him herself, but also her spouse. By the way, Meiji Constitution is the former constitution in Japan, which was abolished by the US after Japan defeated World War II, because it was undemocratic. Moreover, the criminal code and civil code were also undemocratic. Under the family system, which was provided in the old civil code, the members of a family were strictly controlled by the head of a family, like a patriarchy. Tanaka said, considering the purpose of the Constitution, the establishment of the law for parricide, for the reason that the ascendant should be protected in particular, just because he, she is an ascendant, or that the parricide should be morally criticized, is based on the ethical viewpoint of the old-fashioned family system mentioned above. It must be contrary to the idea of democracy. In this way, Tanaka mentioned that the purpose of outgo is feudal and undemocratic, so it is not proper to the Constitution of Japan. This is logic of the minority opinion. What then is the proper purpose of Article 200? A universal ethic or a feudal ethic? I think the theory of feudal ethic is better for two reasons. First, if the purpose is universal ethic, it cannot be explained that Article 200 only applied to parricide. Under universal ethic of love, a family should respect each other. Therefore, the killing of a descendant by an ascendant should be punished more severely than an ordinary case, but the article didn't provide for such case. Moreover, the murder between wife and husband isn't provided, which would also be problematic from the point of view of a universal ethic. Secondly, it is also contradictory to the fact that Article 200 did not address the ascendant's behavior. There is only provision for the descendants and not about the ascendant at all. Tanaka's criticism of the majority opinion seems to be valid.
Okay, now we are ready to move to the next topic. Another interesting feature of the incident is after the judgment. Article 200 remained in the criminal law for about 20 years. 1 year later, 1973, Japanese Ministry of Justice announced that mothers who had killed their parents could be granted amnesty. And in similar cases, prosecutors started to indict defendants with Article 199, not Article 200. However, Article 200 itself wasn't debated soon. Why did it take legislation such a long time to abolish it? The reason was, at the time, many members of Diet disagreed with the decision of the court and insisted that it is still necessary to uphold the traditional rule of patricide. That is why the judges determined that the rule was wrong because of its inequality. Legislators strongly believed that it was so important that the review of it would lead to a disruption of morality, and in other words, they saw that it would destroy the family system, which is the base of the morality of moral social order. The base of the social order of the state. Therefore, until 1995, the criminal law was revised from classical Japanese style. It formally still existed. And why could it be? It was caused by the separation of the three powers. Under the separation of the three powers, the state is divided into branches, and each has independent powers and responsibility for each area. And the Constitution expects that each power on each area to be restrained. However, the separation is just a system which distributes power, and it doesn't mean that each one has to obey the others. And under the democracy, the Diet has the strongest power because the members of Diet are selected by citizens through the voting system. So the argument of Parricide law is a symbolic problem of the division of the three powers in Japan. Because if legislation opposed to the judgment of the judgment of judicature, the law which is even found unconstitutional will not be changed. And in this case, judicature put an emphasis on equality, while legislature put it on morality. Then, which is more important, morality or equality? Especially in such this case, they conflict, and law should choose one of the two. That is a difficult problem. In the first place, a large part of law have a moral content, and it seems to be based on morality. However, when law compels something ethical on people, it might cause several problems. First, morality is essentially based on self-control and intention. So thus, sometimes to add legal force to morality could reduce the value of it. Second, morality could get old-fashioned. As you see, to respect parents might be feudal ethic, and it is doubtful that the value of it is still so big. In this case, the ethic was about to kill the woman who suffered from her father. So it can be said that some morality with power could be so dangerous. By the way, before World War II in Japan, education emphasized courtesy, gratitude, respecting parents or grandparents, and having patriotic spirit. But at the same time, however, it ignored dignity or liberty or diversity of individuals, and seem to have led totalitarian state. So, and at the end of the presentation, we would like to tell you that we have some power to change law through the Diet, because we can select members of Diet through the voting system. So we have to think twice about law and equality and morality, and we should decide which one is the most important thing. That is all. Thank you very much.